Now we're moving document 689, plaintiff's motion limiting number 10 to pre-admit Christopher Brian Wren's medical records, delivery records, and Southern Nevada Health District records. I have an opposition there to document 28 by ETT and a real water opposition to document 812 with a reply document 926. The court's inclination in that is to deny that because this is not the Wren case. It's currently next door, subject to, if you're doing it after January 10th, it may be on a different floor, but it's not in front of this department and it's not part of this case for purposes of a pre-admission of records of a plaintiff that is in a different case and not in this case. And this court wouldn't want to be going into admitting something in one case when realistically it would be within the purview of the judge that has that particular plaintiff in front of him or her, currently her, likely going to him, depending on based on the reassignment. That's the court's inclination. Go ahead, please.
Thank you, Your Honor, and I would respectfully ask you to reconsider that inclination for a couple reasons. Number one, we're not seeking to introduce these records as evidence or to make an issue of whether to prove Chris Wren's claims or to try Chris Wren's claims in this case. These records are relevant to several other issues besides proving Chris Wren's case that are very apt and relevant in this case. I think you've heard a lot today that Terrible Herbst has frequently raised the specter that there were no issues associated with real water until real water moved to the Henderson facility and started manufacturing at the Henderson facility. The Wren records are relevant to refute that suggestion in this case because they show that Chris Wren was identified as a probable real water case by the Southern Nevada Health District's epidemiological investigation, and that he suffered his liver injury. He was hospitalized on August 18th, 2021. The delivery records that we seek to admit are not to prove that Chris Wren drank real water, but to prove that the real water he drank, that the Southern Nevada Health District determined was the probable cause of his liver failure injury, were manufactured before real water moved to the Henderson facility or started manufacturing there. So those records are relevant to refute the suggestions that have been repeatedly made in this case that the problems didn't exist before the Henderson facility. Additionally, Chris Wren is also the basis for the Southern Nevada Health District's August 1st, 2020 symptom onset date in its probable case definition. Dr. Zhang, the Southern Nevada Health District epidemiologist, testified about the definition, and part of that definition that they set before they did the investigation was symptom onset after August 1st, 2020. And I took her deposition and I asked her, well, how did you come up with that date? She said, well, this whole thing started when we got the report of the 5 children of Salt Lake, and that went to Salt Lake Hospital. And so what they did was they interviewed the families of those 5 children. One of the children was Christopher Noah Wren, and they interviewed his family, including his father. In that interview process, they learned that Christopher Brian Wren, he also suffered liver failure and was hospitalized with liver failure. And that was a common part of the investigation was the other similar injuries in the households. And so when they interviewed Chris Wren and realized he had also been admitted with liver failure several months earlier in August 2021, they did the same epidemiological investigation and determined he was a probable real water case. Based on all the family interviews and the 5 kids and their symptom onset date, Chris Wren in August 18th, 2021, he was the earliest onset date. And so they said, okay, well, we have someone who was sick in August 2021. We're going to make the symptom onset date for the purpose of our definition August 1st, 2021. And so that's how they came up with that date. So it's important to show that fact in this case, because again, as you've already seen already, Terrible Herbst has sought to mischaracterize the epidemiological investigation and its findings to suggest that somehow there were no real water cases prior to August 1st, 2020. Finally, Your Honor, and this in its own right, I think under Nevada case law is very clear that prior and subsequent similar incidents are relevant and admissible in a product defect case to show defective condition, causation, or any other element of a strict liability claim. That's the line of cases that we cite in our briefing. The Guinness v. Mapes case, BD v. Thomas, there's Andrews v. Harley-Davidson. There is substantial precedent demonstrating Nevada's long history of extreme liberality in admitting prior and subsequent similar injuries. And in this case, Chris Wren in August 2021 is a prior liver injury associated with real water to the liver failure injury suffered by plaintiffs Jasmine Schaefer, Tina Hartshorn, and Christina Sosa in this case, and subsequent liver failure injuries associated with real water to the liver failure injuries suffered by plaintiffs Myles Hunwardsen and Miriam Brody in this case. So, Your Honor, I think for all those separate reasons, it's certainly relevant. These records and these issues are certainly relevant, and there's really no meaningful argument that these medical records that were both produced in response to subpoenas from medical providers and also were produced by the Southern Nevada Health District because their records kept as part of its investigation are authentic and subject to multiple hearsay exceptions and admissible.
Appreciate it. Councilman Real Water, since you haven't had a chance to speak a little bit, you want to go first on this one?
Yeah.
Who's doing
Mr.
this
Kaufmann,
one?
am
Which
I
council?
addressing this one or you? I apologize.
Address this one, Joe. I got it.
Oh, you got it. Okay, thank you.
Yeah.
Okay, I'll look up to the screen. Go ahead, please.
Your Honor, Matthew Kaufman on behalf of Real Water again. I think Your Honor said it best in your original inclination. This is not the Wren case. Plaintiff is the master of his complaint, and they could have made this the Wren case if they so choose. The other thing I just would like to briefly highlight is that expert discovery has not been done. It has not been disclosed in the Wren case. So at this point, I kind of see Mr. Wren testifying that his liver injuries, or even the insinuation that his liver injuries are caused by real water, is kind of impermissible lay testimony. It's getting into that gray area of lay testimony, masquerading as expert testimony, Your Honor. And that's the only issues I'd like to raise. And with that, we'll stand on our briefing. Thank you.
Okay. Counsel for Terrible Herbst, who's taking this one? Go ahead, please.
Jan Tomasik for Terrible Herbst. Your Honor, first of all, none of these records related to Christopher Brian Wren are relevant, and they shouldn't be allowed in because in doing so, it's a circumvention of discovery. Plaintiffs picked and chose which medical records of Mr. Wren they'd like to admit, and frankly, there's no expert discovery done, and who knows what pre-existing injuries he may or may not have had. Going further, the plaintiffs want to show these records to jump to conclusions that by virtue of Chris Wren presenting to the hospital on X date, it must be related to issues with the Desert Inn facility, and that's wrong as well. Furthermore, Christopher Wren does not consume retail bottles whatsoever. The only consumption he has is of HOD product. And not only is that a distinction between manufacturing plants, even if the product that Christopher Wren consumed was from the Desert Inn facility, it would be manufactured on a different line. The HOD product and the retail product were manufactured on different lines. So it doesn't prove anything related to claims made against Terrible Herbst in this case. My final point, Judge, is just how I laid it out. Even if there is some relevance, it's going to confuse the jury and it's going to prejudice Terrible Herbst. It's too tough to follow a non-party's medical history, his consumption, and the manufacturing pattern under which his product was made. And it's not the same product that, Mr. Hunwardsen claims harmed him that was sold by Terrible Herbst. So, with that, I'll submit.
Okay. Counsel, you get last word. Go ahead, please.
First, Your Honor, I think it's a separate motion on the prior and subsequent incidents, but they cite to no legal support to suggest that you need expert testimony on a prior or subsequent incident to admit it. That's not the case. In fact, the case law says just the opposite. It shows that it's relevant for any number of different reasons without the need to establish expert testimony, including notice, which it doesn't even matter if it's
Can I
correct
stop
or
for a
not.
quick second?
Yes, sir.
In light of I have to say, the stipulation I haven't yet seen, but has been represented, right, to have a certain scope. How does that notice component still apply for real water? Different concept for Terrible Herbst, ETT, right? But how does that even apply for real water?
Yes, Your Honor. The stipulation is only limited to liability under the strict product liability claim for compensatory damages. It does not apply to punitive damages, which it provides that plaintiffs will still pursue that claim at trial. So it is.
So you want to use Wren's medical records for punitive damages in the Hunwardsen case when Wren's not a part of it for punitive damages? Is that what?
No,
I'm
Your
just
Honor.
trying to get the clarity here.
For notice of related to the admissibility and relevance of prior and subsequent incidents. You asked how it was relevant to notice as to real
You're
water.
asking this for pre-admission. Remember, counsel, right? This is for pre-admission. We're not at any aspect. That's right. So
Yes, Your Honor. We're
pre-admitting
asking for pre-admission because all the requirements for admissibility are met. The records are authentic. They're not hearsay, and they're relevant. I understood your question to say how is it relevant to notice as to real water. We still have a punitive damages claim against real water, and so any other prior incidents are relevant to that claim. So the stipulation doesn't affect that. But even if there was some question about that, it's still relevant to the claims that we have and the arguments and issues that are raised by Terrible Herbst. And the only reason I was raising the issue is to say that for these types of relevance questions, expert testimony is not required. But really, that's kind of a moot issue in this instance anyways, because the Southern Nevada Health District determined that Chris Wren was a probable case. Terrible Herbst's argument was that we somehow circumvented discovery by picking and choosing the records. Your Honor, this whole thing came about because Terrible Herbst's expert suggested that this was not a retail problem. It was a problem limited to the Henderson facility where they didn't manufacture retail products. So obviously evidence of an injury related to product that was made at the Desert Inn facility is relevant and important to refute that type of really evident questions. Again, they argue that we're asking you to accept a conclusion. It's not our conclusion that real Chris Wren is a probable case. It's the Southern Nevada Health District's conclusion. There was an argument that he didn't consume retail water, and there's a distinction between manufacturing facilities, which is incorrect. At the time that Chris Wren was delivered the water that made him sick, they hadn't moved to the Henderson facility. They hadn't split their operations with the Mesa facility. Both the 5-gallon and the retail water were made at Desert Inn. And then the argument is, even if it's made at Desert Inn, they're made on different lines. Well, Your Honor, I didn't hear how that is relevant. What evidence are they showing to you that suggests that this water that they made on 2 different lines at the Desert Inn facility has any impact in the defect or the hydrazine being in the water? I think it's been suggested, Mr. Parker mentioned it, they're just throwing stuff against the wall. They don't have any evidence, so they're saying, well, it's 2 different lines. But what does that mean? Where's the expert who says that this problem came from a specific line? It doesn't exist. They're just trying to, keep out all the relevant evidence that shows the groundless assertions that they're making just lack any basis in fact or evidence. And I think that's the final point, Your Honor, is the argument is that, oh, this will confuse and prejudice the jury. Essentially what they're saying is they can say that all the probable cases as determined by the Southern Nevada Health District came from the Henderson facility, but we can't say not this one. And that, Your Honor, in our view would be wrong and unfair. And we would ask that these records be pre-admitted on that basis.
Was Wren ever named as a witness in this case? 16.1 disclosures?
Yes, Your Honor, he's named as a witness.
When?
I don't know the exact date, but from the outset,
On this case, he was named as a witness, so
in
he was
this
subject
case,
to being
all
deposed?
plaintiffs, he was not deposed in this case.
No, I'm sorry. Was he named as a specific witness in this case so that he could be deposed during discovery, was my court's question.
Yes, Your Honor. We named all the plaintiffs in all the cases as witnesses in each case.
There was a statement on, the reason why the court was asking the questions, on page 7 of the opposition, they said he was not named as a witness.
That is, to my knowledge, incorrect. And I can say this, that this same issue came up in the Gallagher case.
This is Hunwardsen, this is not Gallagher.
I know, and I'm not suggesting that it is, but this same issue came up in the Gallagher case in response to the same expert's deposition, and we produced the records related to that to Terrible Herbst on this point to show that Chris Wren refuted this idea that all the probable cases came
Do you
from
understand
Henderson.
my question was really very specific, right? Was he named as a 16.1 witness in this case, and on what basis was his provided for his testimony for these cases?
Yes, and my point is to say that, yes, he was named, and the defendants knew about this issue long ago and had every opportunity to depose him.
Okay, well then I'm gonna have to ask Terrible Herbst why they, is that correct, and is that an error on page 7 of the opposition where it says because plaintiffs have not identified Mr. Wren as a witness or shared Mr. Wren's medical records with Terrible Herbst, any testimony or evidence of Wren's alleged injuries, including his medical records, may not be admitted or referred to? Was he or was he not a witness?
I believe that's accurate. If it's not, I would stand on the assertion that, anyways, it's not relevant. I mean, the basis under which plaintiffs are now attempting to use a witness is perhaps an expert opinion, and it's not germane to the claims.
Counsel, I wasn't, in fairness, remember I asked you a very specific question. There's a statement, right, in a pleading signed by attorneys that makes a statement as far as somebody being not identified as a witness. Counsel for plaintiff is saying that that's not accurate because they're saying they did name him as a witness. I'm asking counsel for ETT, Terrible Herbst, do you agree or disagree? Because you put in your pleading that he was not named as a witness.
At this time, I'm not sure, Judge. I'd have to go back and look through the NRCP 16.1s.
So how was it put in a pleading if it's didn't somebody look at it before you popped it in a pleading? Under Rule 11?
Yeah, I mean, as I stand here today, I don't recall seeing Christopher Wren in a 16.1 as a witness.
Counsel, do you have a date when you disclosed him as a 16.1 witness?
I don't, but if I can have a couple minutes, I can ask for it from my office.
Okay, well then I'm going to move on to the next one. I'm going to circle back on my ruling here, right?
Your Honor, on a separate matter, I was going to request a comfort break briefly.
Sure. It's perfect time for a comfort break because maybe I can rule when I get back, when you all get back, right? Perfect timing. Okay, it is 2:35. Shall we come back at 2:50?
Sounds great.
Okay, appreciate it. Thank you so very much, everyone.
Thank you.
I'll pause. Yeah, well, let's go back on the record because I have to ask. Oh, wait, here they come. Here at least comes one. Councils, it's time, right? Yeah, please be prompt so we can get through all these that you filed, right? So do appreciate it. Okay, before we went off the record, the court asked the question because there seemed to be a lack of clarity between two of the parties about whether or not Mr. Wren was listed as a witness. So was Mr. Wren listed as a witness? Counsel for ETT?
Jan Tomasik for Terrible Herbst. We pulled up plaintiff's disclosures and he is not listed. The closest they come to doing so is attempting to adopt by reference all witnesses under the Wren action, but there's no...
You can't do that under 16.1,
That's right.
right? Because you have no idea that's a moving target, right? 16.1 tells you have to identify each and every witness, right? Plus the testimony they're going to give, particularly since 2019, right? It has to be substantive. Can't be. So, counsel for plaintiffs, do you disagree? Do you say that there's a place where you specifically named Wren?
No, Your Honor. As far as the coordinated case, general witnesses that apply in all the cases, we disclose only in Wren. In each of the other case disclosures, we included a reference to refer to the general witnesses disclosed in Wren.
You can't do that for purposes of trial. You know that. Because, right, you have to make it clear of what actually going to be your trial witnesses. And are you saying that there's a special master order or something that said that that was compliant? Because coordinated discovery doesn't mean coordinated adoption of different things. So, short answer is you don't have something specific in this case, correct?
Other than the reference to the general witnesses listed in the Wren disclosure, that we organized it to say, okay, here are the general witnesses that apply in every case, and here are the case-specific witnesses. In each individual disclosure, we said, general witnesses, please see the general witnesses disclosed in Wren, which the special master did require in everything in Wren is served on all parties in all cases, which is why we did that. And then the individual witnesses that are case-specific are listed in each case.
Did you ever modify it for purposes of trial witnesses, in this case, Hunwardsen?
We have not made our final pretrial disclosures yet.
I'm asking as of today, counsel.
Not as of today.
Pretrial disclosures are pursuant to the rules and the dates set out. Okay. Court's going to deny plaintiff's motion eliminating number 10 to pre-admit Christopher Brian Wren's medical records, live records, and Southern Nevada Health District records. Realistically, you haven't met the standards appropriately for the pre-admission. There's even a question with regards, excuse me, to the relevance of said records. The court adopts the analysis in the two oppositions. It is so ordered. Moving on. Document 645, please, which is motion eliminating number 19 to preclude testimony and arguments regarding a purported lack of injury claims and lawsuits, quote, legal history, end quote, related to real water prior to August 1, 2020, or outside Clark County. Here's the court's inclination, or the court's inclination is granted in part and denied in part. It is granted because realistically, see the analysis the court just gave in its inclination in Wren, right? Wren's not relevant. All the people who weren't ill also aren't relevant. This trial is about the actual plaintiffs in this case, not the rest of the millions we have in the community. You all have phrased a whole bunch of different numbers of who actually drank it, right? That's not this case. So the reason why it's denied in part without prejudice is because nothing would be precluding the actual chronological history. For example, you all have articulated a lot of different pleadings about the Southern Nevada Health District and when the Southern Nevada Health District said its outbreak dates are. So the court's inclination is not to preclude those chronological history type testimony coming in an argument, but is to preclude people who are not part of this case. So everyone who drank real water and didn't get sick is just as relevant as at this juncture as with regards to the court's prior ruling with regards to Mr. Wren. This case is about certain plaintiffs, certain defendants. That's the court's inclination. Counsel for plaintiff, it's your motion. Go ahead, please.
Nothing to add, Your Honor.
Counsel. So in this one we have, and that was document 645. Document 843 was ETT's opposition. Would you like to be heard? Go ahead.
Tomasik for Terrible Herbst.
Sure, go ahead.
I guess the only carve out, Your Honor, in this case, while Terrible Herbst doesn't intend on bringing a lack of legal history argument, there are bona fide defenses as to the absence of injuries as to notice as to Terrible Herbst. And part of our opposition, and we have another motion to pre-admit NEVBEV employees. So as long as that is not precluded, which would be admissible under Wilson, because it's a contemporaneous product, contemporaneous consumption, as long as that doesn't fall under any exclusion, Terrible Herbst would agree.
This court's going to do a little bit more of a clarification of what the that is in your that statement, please. You said as long as that is not included, but I need an better understanding, please,
Right.
of what you're referring to as the that.
As long as Terrible Herbst is not precluded from bringing evidence of lack of claims in legal, I apologize. As long as Terrible Herbst is not precluded from arguing an absence of injuries related to the product, then we do not have any objection.
Court's not ruling on motions that are not yet before me. I'm ruling on the motions that are currently before me. So when you're saying the absence, you're talking about your motion eliminating number 20 to pre-admit evidence that Nevada Beverage Company's employees drank real water without incident. That's not before me. Document
Right, but if there is
675.
anything in plaintiff's motion here attempting to preclude that, that is our only caveat.
Okay, I appreciate it. Counsel for Real Water, do you wish to be heard?
Yes, Your Honor. Thank you, Mark Love for Real Water. Plaintiffs have a number of motions coming up down the road on this issue where they're going to argue
Hold on
that
a second. Somebody's phone is ringing in the background. It appears it might be.
Paul was trying to call me to answer that question, and Mr. Pepperman was.
Oh, no, okay. I just want to make sure everyone gets a clear record, so we need to. So, counsel, and you realize you did a non-substantive joinder, so
right.
feel free
So
to
just
adopt
joining
the
in on
arguments of
Terrible
ET&T.
Herbst's comments, I just want to point out to the court, Your Honor, that plaintiffs have a number of motions where they will seek to introduce cases like Mr. Wren's to show that there's notice for the purposes of punitive damages. And so there's pretty strong case law that says that if incidents come in to show notice, then the lack of incidents can be brought in to show a lack of notice. And so I would just suggest, Your Honor, that to the degree that there is substantive evidence where, and we're not talking about litigation or lawsuits, but if there's clear evidence that there was a lack of people getting sick from product X in a certain year or whatever, that be allowed to come in as a matter of completeness for the purposes of going to notice.
Okay, so you're asking for a similar carve out that what AT&T is saying, correct?
Yes, please, Your Honor.
Okay, no worries. We'll hear what your final word. Go ahead, counsel.
I understand that he's bringing in a completely different motion to eliminate, which is the motion to pre-admit the customer complaints. That's a completely different standard, completely different issue. So,
And that is why the court referenced the other motion, and I mentioned that the court's ruling on this motion. I'm hearing their argument. You all get last word, so who's doing the last word on this one?
I don't think I have much to add. I just echoing Mr. Kemp's statements that the issue before you is narrow with respect to evidence of lack of prior claims. There were prior claims, so this argument that the lack of probable claims or people drink real water and didn't get sick, I think your inclination to say that that's not relevant is correct, and we ask you to grant the motion as you previously stated.
Okay. The court is going to grant the motion in its narrow context, granted in part and denied in part what the court said. The court's not taking a position or a ruling on issues that are not yet before me in subsequent motions. The court's also not making a determination on certain aspects that may or may not come up in trial and what people may need to respond to in said trial. What the court is looking at is the narrowness of document 645 and is ruled granted in part and denied in part consistent with its inclination. It is so ordered. Moving on to next one, document 685, plaintiff's motion eliminating number 7 to pre-admit real water marketing videos and 2020 still ad and the real water business plan. I have an opposition there too, document 852 by ETT, 891, a joinder by real water, reply 959. Now the court is aware that last night around 7:04 p.m. there was an OST. You can appreciate this was already set for hearing today under the EVCR. There's no way the court can hear something in less than a judicial day's notice. In fairness to everyone who knew and was being prepared for today's hearings, this court wouldn't find it appropriate to sign such because we were getting to it despite the statement in said OST that somehow you give the court an OST at 7:04 means the court's not going to get to a particular motion on a hearing day anyway. Well, we are there. We were always planning on getting there, and in fairness, parties can't, in the midst of these set proceedings, change the landscape. So the court is not going to sign that OST. It doesn't meet the standards of an OST, and the EDCR would prevent it in any way, given the fact this was preset specifically for today and waited till, and I appreciate you took a depo on the 11th, but...
Yes, Judge, this motion goes to advertising. And let's start with the reason advertising is important to the strict liability case.
Sure.
Advertising was the key in Shoshone for the extension of strict liability to distributors. Mm-hmm. If you go back and you read Shoshone, which is a 66 case, Shoshone cites Prosser, the fall of the Citadel, and Prosser talks about the fact that distributors advertise the product and they make profits off of selling the product, and that's the reason that strict liability extends to distributors. That is the legal foundation for it. In this case, and we know this from not the Gallagher trial, but other trials, jurors have difficulty understanding why distributors are automatically liable for a defective product. You know, they sit there and even though it's an improper argument, a lot of defense attorneys insinuate, well, we didn't make the product, we didn't have any notice, we didn't. But that's why we always, when we try a product liability case against a distributor, we want to show that they were involved in the advertising. So this motion pertains to the principal advertising in the case, which are the marketing, the 2 videos, and then the still advertising. All right, so the 2 videos, there's video number 1 and video number 2. One is a woman, and then the other one has a number of celebrities in it, including Melvin of the Spice Girls and some BMW rider who, frankly, I don't know who he is. But anyway, these two ads were played on Terrible Herbst gas pumps from 2010 to at least 2018 and 19. Mr. Hunwardsen specifically testified that he saw these videos. That's in his deposition. That's not disputed. They try to say, oh, well, maybe he saw them somewhere else at a Chevron. Well, there's no evidence that Chevron ran these videos. In any event, the opposition takes the position that this just didn't happen, that we had absolutely no contact with real water, we being Terrible Herbst, at any time, that no marketing video ever ran on a gas pump at real water, that we had no communication whatsoever with real water. That's what the whole opposition is premised on, Your Honor. And we took the deposition. That just is not true, Your Honor. That is just not true, and that's the subject of another motion to strike, which is, I think, being set down for next week. I'm not sure about that. I don't know. There might have been some discussion on that. But in any event, on this particular motion, these are the two videos that were played on the Terrible Herbst gas pumps. Now, what did they do to establish that they weren't played on the gas pumps? Recognize, and we put the advertising literature from the manufacturer of the gas pump video technology, which is called the Applause Network. We put some marketing literature in as an exhibit to the reply, and that prints out a comprehensive report showing what ads were played, when they were played. They didn't give us that, Your Honor. That has been produced to disprove the assertion that the videos ran. Okay? All they've done is they've gone to three Terrible's executives, Mr. Walters, Mr. Kemper, and Mr. Breeden, and said, hey, do you remember any of these? Oh, no, we don't remember. So that is the evidence that they're offering to disprove the assertion that these were played. And again, Mr. Hunwardsen testified that he saw these. So, Your Honor, we think that these videos should be pre-admitted, especially, I think, when we get into the, I don't see any way to avoid an evidentiary hearing on it, but even if we don't get to an evidentiary hearing, when we get to the motion strike, I think the court's going to be very troubled by the position they've taken that there was no contact whatsoever with real water when clearly there was contact. And that brings me to the second piece of advertising, the 2020 still ad. They admit that they ran the 2020 still ad. Okay. And by still ad, that would be an advertisement that is just the picture on the gas pumps. There's not a video being played. It's the same screen, but it's a still ad. And so they have these interactive gas pumps. You push the button, and that prints out a ticket. You can take the ticket, you can go into the store, and of course they want to drive people in the store because once they're in the store, they buy other stuff. So you present the ticket, and you get a free bottle of real water, which real water paid for. So this program, they admit that they ran in September or August and September of 2020. And again, they were selling a lot of retail bottles, Your Honor. According to their records, they were selling approximately 200,000 a year in 2019 and 2020. Again, Mr. Hunwardsen's a 2019 case. So what we want to do is we want to pre-admit this. We want to show the two videos during the opening statement, and we probably want to reference the still ads in the opening statement, but I think the two videos are more important to us. And the primary reason for this is to explain to the jury from the outset how Terrible Herbst was the marketing arm for real water. And it was the marketing arm for real water, Your Honor. We're going to call these witnesses to trial. Mr. Walters, the person who doesn't remember anything, even though we've got letters to him, and he even got home delivery, free real water he got. He doesn't remember ever having any communications with real water. So we're going to call these people to the stand Your Honor, and discuss the advertising, but we want to show at the outset this particular advertising, the two videos. And their only arguments, the first are the memory argument. Oh, we don't remember. I don't think that's competent evidence. But their second argument is they argue and moan that we can't lay a foundation. That argument is gone after Monday because they can't stand up with a straight face and say that I can't lay a foundation for these videos based on the testimony of the witness Monday, which will authenticate them at time of trial. So I have a good.
Excuse me. Okay.
Ready, Your Honor?
I'm allowed to sneeze in the middle of the hearing. Go ahead, please.
Yeah, I have bad allergies too. So I have a good faith belief that I can authenticate these things because Mr. Randolph will be able to testify. Not only did he see them personally with his own two eyes playing on the Terrible Herbst pumps, he will take the witness stand and say he was there when they filmed the two videos. He will say that he met with Mr. Walters 15 times, that Walters approved the video. So I have a good faith belief that I can lay a foundation for these. So there shouldn't be any objection on foundation at the present time. So relevance, I think I've already discussed. And for those reasons, Your Honor, we think they should be pre-admitted. The last point, I'm sorry, I didn't talk about the business plan. The business plan, we filed a motion to pre-admit it. Real Water said, hey, well, what do you need it all for? And I said, we don't. We don't need it all. So I've agreed to redact all the portions of it except for the confirmation that the videos were played at Terrible Herbst, and a remark on how effective they were. And so with regards to the business plan, we just want to admit that one little snippet of it. And that document was produced by Real Water. It's got a Real Water bait stamp on it. And again, on top of that, Mr. Randolph authenticated that too. So there's no argument to suggest that I can't authenticate that. So those are the three pieces of evidence we would like pre-admitted, Your Honor.
Okay. In ETT's opposition, this is going back to the Chevron versus Terribles. They cite from the deposition.
I'm glad you brought that up.
Chevron, and that's only the best gas he uses.
Okay, so they are hypothesizing to the court that there's, first of all, Terrible Herbst has 120 locations. That's not in dispute. They're the biggest Chevron dealer. There are some stray Chevrons out there that they haven't bought yet. And I say yet because there seems to be a big Pac-Man game to them. But in any event, there are some stray Chevrons, all right? We asked Mr. Randolph if any of those Chevrons, number one, sold Real Water. He testified that Chevron did not, National Chevron did not approve Real Water. We asked him if there were any videos in those Chevrons. And again, Mr. Hunwardsen testified he saw a video. He said that no, that there were not videos of those Chevrons. So they're asking the court to assume that there was some mistake here based on the premise that, number one, these other Chevrons sold Real Water. Absolutely no proof of that whatsoever. Number two, that these other Chevrons played videos. Again, no proof of that whatsoever. And the proof's going to be directly to the contrary, Your Honor. So that other Chevron argument doesn't take them very far, and I think we're going to get into it more when we get to the three complaints that they disavow knowledge of, because they came in and they said, oh, well, we don't know about any complaints. There's never been a complaint against Terrible Herbst. We have 3 different complaints filed by Terrible Herbst customers in 2014, 2 of which talk about a gasoline-like substance in the water. And they're trying to get out of those too by saying, oh, well, it just says Chevron here. But since we know these other stray Chevrons didn't sell Real Water, couldn't be the other stray Chevrons. But,
okay. Appreciate it. So let's go to, I have an opposition by ETT, and let you go first, and then Real Water. I'm going to let you go because you didn't join her. Go ahead, counsel.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst. I'd like to first address counsel's comment about his client's testimony, followed by the authentication argument, relevance, and then prejudice. So with respect to counsel's statement that Mr. Hunwardsen testified that he saw these exact videos, that is inaccurate. It was at Mr. Hunwardsen's deposition. He was asked about seeing a video that he saw on a Chevron gas pump in 2016. That is it. If Mr. Hunwardsen would have seen these specific videos, I would expect to see a declaration or affidavit saying that he did so, but we don't have that. We don't have evidence Mr. Hunwardsen actually saw these videos, at least not yet, and not on the record. Second, with respect to authentication, NRS 52.015 requires that all evidence be authenticated. That evidence can be authenticated by a witness under NRS 52.025. However, no witness in the record has authenticated any of these commercials or even the business plan. Nobody from Rural Water has been deposed in Hunwardsen to authenticate the commercials, the videos, or the business plan. Mr. Kemp is referring to a witness who was deposed in the Henry case.
I can't have the printer going off while she's speaking. I mean, come on. In fairness, let's get them a clear record, okay?
My apologies, Your Honor.
You can hear.
Almost done.
That doesn't mean, that means it needs to stop right now, please. Come on, we're in the middle of, wasn't going off when plaintiffs were speaking. Can't do it when defendants were speaking. Fair is fair, folks. Come on.
I tried canceling it.
Thank you so much. It could be done outside the courtroom, not courthouse is what I meant to say. Okay, sorry. Counsel, you were saying, I couldn't hear the end of
Sure.
that. Thank you so much.
To my knowledge, the only witness who has talked about any of these pieces of evidence that plaintiffs seek to pre-admit is Mr. Randolph, who was deposed on Monday in the Henry case. He was deposed in the Henry case because, to my knowledge, he has not been disclosed in the Hunwardsen case, other than if we were to take perhaps the incorporation that was discussed earlier. So that testimony is not before Your Honor. What is before the court is a lack of any authentication by any witness who has actual knowledge of these videos or the business plan. So that alone, I would say, precludes pre-admission. But beyond that, the videos are irrelevant because nobody has tied them or connected them to being shown on Terrible Herbst gas stations. All evidence points to these videos being made somewhere in the 2010, early 2000s, certainly before 2013 timeframe, based on what we're seeing in the videos as well as what we see in the business plan. So first of all, taking the first video, which is 31 seconds long and relates to the Miss USA pageant. That video specifically has a date on the lower left corner of 2009. That video has no relevance to what Mr. Hunwardsen believes he may have seen in 2016. They jump from here's a video in predating 2013. Here's Mr. Hunwardsen's testimony that he saw a video at a Chevron, and therefore it must be the same video. But there's simply no evidence of that. And to the point that not all Chevrons are owned by Terrible Herbst. Terrible Herbst does own a number of Chevrons. We're not disputing that, Your Honor. But that has not always been the case. These acquisitions have occurred over time. And with respect to even the 3 complaints that the plaintiffs are raising now that are not in their papers, those are from 2014. And 2 of the 3, the 2 that they primarily rely on in support of their hydrazine was in Terrible Herbst retail bottles, were not even owned by Terrible Herbst at that time. That's 2014. There's 3 complaints from 2014 that they're referring to. Getting back to these videos, there's equally a lack of evidence connecting these videos to any Terrible Herbst display or digital monitors. No witness has said that. There's been a lot of assumptions and a lot of conclusions, but no connection. There's no connection to what Mr. Hunwardsen saw to these videos, and therefore they're irrelevant. They're also prejudicial because you hear what counsel plans to do with these. And this is a very dangerous situation because we've got commercials or videos made by who knows? Nobody knows who made them. Nobody knows exactly when they were made. We can make assumptions based upon the dates on the videos and what they're referring to inside the videos. And we've gone through that in detail in our opposition. But to suggest that from those 3 videos, Terrible Herbst is now somehow the marketing arm, that is the exact case that they would like to make here, Your Honor. They would like all of the liability to fall on Terrible Herbst. Real Water clearly is in bankruptcy. So we're left here. We're the ones left standing, and they're looking for the deep pocket. And the way they get there is just what counsel said, by showing somehow that Terrible Herbst was the quote-unquote marketing arm of Real Water. But that's simply not the case. The evidence my clients have put forth is that they've looked for these commercials, these videos. They did not find them. They didn't say we didn't show them back in 2010 or we didn't show anything back in 2010, but they certainly don't fit the format. They don't fit with our recollection, and they don't fit with anybody's testimony who said, yes, those were played on Terrible Herbst digital monitors in 2016, and that is what Mr. Hunwardsen saw and relied on in purchasing Real Water. So not only is there no authentication, there's no relevance of these videos to this specific case. And it would certainly be prejudicial to have the jury conclude or to allow pre-admission of these videos, and even the business plan, which makes references to Terrible Herbst, that apparently is going to be redacted to such a limited part. I haven't seen that yet, but that's another issue, because inside of that business plan, there's a lot of comments, but still nobody's talked about that business plan. Was it distributed? Was it a draft? Was it a hope or a dream? We don't know, because I don't have... Are you
saying it wasn't produced in this case?
No, it was produced. Obviously, they got it.
So it would have been subject to anyone wanting to take a deposition, do any discovery on it, correct?
Yeah, I would have no reason to do any discovery on that particular business plan from 2010. No witness said that business plan involved Terrible Herbst.
I'm sorry, I thought you said the business plan on its face is being represented includes Terrible Herbst in it.
That's what they're referring to. There's a statement somewhere in there about Terrible Herbst showing some videos. That's why they want the business plan.
Right, so what the court was asking, if the business plan was produced, and if the business plan was available for everyone to review, right, to see if they wanted to do any follow-up discovery on it, right, whether through depositions, written discovery, etc. I was trying to see how that links to the idea of why you might choose not to do it, but it was available to do, wasn't it?
It was available to us and available to the plaintiffs to do. If they wanted to present evidence, its burden is on them to authenticate that evidence. I don't want to use this evidence. I'm trying to exclude it.
Okay.
And going to the direct evidence, what we do have in the record is nothing from Mr. Hunwardsen saying that he saw these videos. Nothing from a Real Water witness saying they produced or sent these videos to Terrible Herbst or they were played on Terrible Herbst. We don't have anyone from Nevada Beverage, a distributor for Terrible Herbst through Real Water, saying that there was any type of marketing plan. What we have is one coupon. And that coupon, at that point, Mr. Hunwardsen had stopped consuming Real Water altogether. So to allow that would be for what? For no other purpose than to make some argument that Terrible Herbst has somehow been the marketing arm of Real Water since 2008. And there's simply no evidence of that. At the very least, Your Honor, there's been no authentication of these pieces of evidence or proposed evidence, and they should not be admitted, and certainly should not be pre-admitted until somebody has testified about them. And with that, I'll submit, Your Honor.
Okay, thank you. Counsel, you get last word. You understand I'm hearing two very different versions and very different decades. But
That's true, Your Honor. I think the issue is whether we can authenticate these or not. And their response was, oh, you can't authenticate him because the witness wasn't taken in Hunwardsen, it was taken in the Henry case. True, we can't read the deposition because it wasn't taken in this case and it was done after the discovery deadline, but he's a disclosed witness. I can call him on the stand and he can authenticate it there. There is no rule of law saying, first of all, that I even have to depose an authenticating witness. In fact, in most cases, when we do authentication, medical records, the like, there's no deposition taken to authenticate, okay? So their suggestion that we can't lay a foundation because we didn't depose the witness in this case, that is wrong. The real issue is whether we can authenticate the documents. And she knows we can authenticate the documents because the guy Monday authenticated each and every one of them. He was at the sessions where they filmed the videos. He identified the videos. He said that he saw them on the Terrible Herbst pumps. He said that he recognized the marketing plan, which has a big paragraph that refers specifically to him because he was the vice president of sales. And he also says it was used. It's not a draft. You know, counsel saying it was a draft, that's something they're making up. There's no evidence whatsoever to support that, Your Honor. But so I have a witness who can authenticate both the videos, there's two videos, and can authenticate the business plan. And that should be, and the business plan is self-authenticating. It's a real water document that they've had for years. You know, why they didn't think it was important to explore a statement in the business plan that said that Terrible Herbst ran these video ads on their stores, on 110 stores for years, and that it was a particularly effective form of advertising. That's their decision, Your Honor. That's not my decision. But it was out there for them to look at. So for those reasons, there's no reason not to pre-admit these because I have a good faith belief, and they know. They were at the deposition. They saw this guy authenticate all these items. They know as soon as I put them on the stand that they're going to be authenticated. You know, so to run to this argument, oh, the testimony had to be done on Hunwardsen because that's the only thing that can be used at the trial. There's going to be a lot of witnesses testified at this trial that weren't disposed in the Hunwardsen case, Your Honor. They were disposed in the Common case, the Wren case. You know, Mr. Marlowe was deposed in the Wren case. Mr. Jones was deposed. Nobody was deposed in the Hunwardsen case because it's a plaintiff-specific case. But the real issue is whether I can lay a foundation, and I can lay a foundation. That's in the records. Now, their final argument is that, and before I get there, I would notice that they are running now from their primary argument. Their primary argument is that they proved to this court that at no time did any video ad for real water run on a Terrible Herbst gas pump. That was the argument they started with, okay? They don't like that argument anymore because it's proven to be false, not just by the testimony, but by the documents. So they're running from that argument. Now they're going to these arguments such as, oh, someone didn't testify on Hunwardsen, so you can't lay a foundation. But they've left that argument, Your Honor, and that's the principal point here, because they have raised a serious credibility issue. And I think this is going to be the most serious credibility issue in the trial. And the credibility is they have taken the position that they had no communications at any time with anyone at Real Water, that they never ran any video advertising for Real Water. They do admit they ran these still ads, but they have taken those two positions. They have submitted affidavits of 3 different Real Water executives saying that. Mr. Walters, Mr. Kemper, and Mr. Breeden. And then Mr. Kemper was deposed as a 30B6 witness. One of the topics was whether or not they had communications between Terrible Herbst and Real Water during the years 18, 19, and 20. He testified, and this wasn't that long ago, he testified that there were absolutely no communications. So that is the central credibility issue in this trial, Your Honor, because if the jury determines that they were not being honest with regards to those points, they can draw negative inferences on anything they say. So that brings me to the last item, these 2020 coupons. So they're saying, oh, well, that's not relevant, Your Honor. Well, the reason they're relevant is for two reasons. First of all, it just shows the continuation of the marketing program that was going on since 2000 from 2010. But secondly, both Walters and Kemper, and again, Kemper testified to this at his deposition. They testified that there were no communications, no contact whatsoever between Terrible Herbst and Real Water in 2018, 2019, and 2020, the exact time period that these coupons appeared on all the pumps. Not only did there have to be, common sense tells us there had to be communications, but the witness Monday talked in depth about how this program was run. You know, for Terrible Herbst to come up and suggest that all of a sudden they ran a 2-month campaign for Real Water where you could get free Real Water and they had pictures of Real Water on the pumps and that no one at Real Water was involved with this or authorized this, so there's a big credibility issue here, and that's why those things that they admit are authentic because they produced them. They're arguing they're not relevant. I think I've explained why they're relevant. But, Your Honor, so these should all be admitted because, like I've already said, there's no dispute on our ability to authenticate them. The only dispute on the third one is to the relevance. And, Your Honor, unless you have questions.
I do. 2000, okay. The additional argument raised by Terribles is they didn't necessarily even own the stations back in 2010, which
Correct.
are at issue. Where does this court have from an evidentiary basis that Terribles versus somebody else owned the stations at issue for the 2010 video, please?
First of all, Your Honor, there is testimony that was given in another case that we've attached from Mr. Kemper that they have destroyed all the customer records preceding 2020. So they have destroyed all the records for 2014, 15, and forward. So anything they have, we don't have a whole deck here. Where we got these complaints is from Real Water. There's 3 complaints, and the 3 complaints say Chevron. I think they say Chevron on 2, but maybe they do on all 3. But they have cross streets on them. St. Rose and Spencer, St. Rose and Maryland Parkway. So you can determine what is the closest store to them. And so counsel said that we didn't own the store at that time. That's what Mr. Kemper said in his affidavit. In point of fact, there was no store in 2014 at this location that they claimed the complaint came from. That store was not built until afterwards. So it couldn't have come from that Terrible Herbst store. It has to be an adjacent store, Your Honor. But with regards to these 3 complaints, they're all admissible as notice to Real Water. They're admissible as notice to Terrible Herbst because one of the complaints, and this is one of the gasoline-like substance complaints, says that the Real Water investigator had discussions with store personnel with regards to the problem and asked them if they had had any similar problems, and they responded no. So not only was Terrible Herbst notified, but they were part of the investigation back in 2014. But those 3 complaints aren't subject to this motion, Your Honor. This motion is not seeking to pre-admit those 3 complaints. This motion is solely focused on the 2 videos, the business plan, and the still advertising program.
Point the court, please, to where in the pleadings I have that they actually, I heard your analysis, right? But is it, the challenge I'm having is with the 2010. Honestly, I'm inclined to grant in part and deny in part without prejudice. I'm inclined to grant the stills. I mean, it's clear it's 2020, it's in irrelevant time frame. It shows terrible, it shows a coupon. I'm inclined to grant the business plan in a redacted form if that's pursuant to you all's agreement, as long as those redactions get reviewed in the court. If the court has to address any dispute in redactions, the court would need to do that pre-trial, right? Because that would need to be brought to the court's attention. The 2010 videos I'm having some challenge with because the broad difference of how these pleadings are presented to the court and the support for each of them. And I appreciate you all have taken a lot of depositions, done a lot of different things in a lot of other cases, but I have to focus what actually is in Hunwardsen. So
that's right. First of all, there's no evidence that the videos were made in 2010. The only evidence on the date is from the business plan. The business plan, we believe, and Terrible's believes also, was written sometime in the first part of 2013.
I'm looking at page 6 of your reply.
That refers to there's another type of advertising, Your Honor. There is a 2010 letter that talks about cutouts that were put out there, display boards. Okay, that's a different type of advertising. That doesn't refer to the videos. We think the videos were run then. We don't know that they were these two videos, but we do think videos were run at that point. The problem is you have a defendant saying that absolutely no videos were run at any point in time, and we know flat out that's not true. Okay, so they have the
court's focusing on whether or not the actual videos that are subject to this motion meet the appropriate standards as what's being requested in this motion versus your general comment that videos were run. That's a different issue. That's why the
that's
court's
a different
focusing
issue.
on.
So what we have to prove to pre-admit these is that they can be authenticated. We actually only have to prove that there's a good faith belief that we can authenticate them. I don't think there's a challenge seriously made that these videos cannot be authenticated other than the deposition was taken in Hunwardsen, not in this case. Mr. Randolph will come live. He lives here in town.
But you're asking, see, here is the distinction, right? Here you're not just asking for a reference and opening statement, right, to a fact that's going to be presented during evidence. Here you're actually asking police, as being presented, to play the videos as they are pre-admitted evidence, and that's why the court's having to ask the
Well,
questions.
technically, I don't have to pre-admit the videos to play them. I just have to have a good faith belief that they will be admitted, Your Honor. I mean, I don't like going out on a limb like that. That's why I try to get stuff pre-admitted when there's really not a dispute. But technically, I could do that if I wanted to.
As evidence?
I can show evidence to the jury if I have a good faith belief that it will be pre-admitted, or that it will be admitted.
Court's ruling with the motion that's currently before and how it's
Right.
presented, and so that's what the court needs to rule on. One minute.
Well, Judge, this is why I filed, we had a debate at the office about whether we should just file a supplement to this. And I said, well, that wouldn't be appropriate even if it's just 2 business days late because our reply was due on Wednesday. So that's why we filed the motion for leave to file an addendum.
Do you understand I had to deny that OST because
Right.
filing something at 7:04 p.m. the night before the
I'm not
hearing's
trying to
already
get it
set.
heard today, Your Honor.
Yeah.
Okay, because
Well, that's why I'm focusing on the police. Okay. Give me a quick second. Let me look. Double check one thing.
Judge, I have no problem holding the 2 videos until after we've heard that particular motion on the addendum.
You want me to
Which
defer, you want me
make
to
the
defer on
ruling-
that? If you're requesting, it's your motion. If you want me to defer on that, we've got some
I
time.
would defer on the 2 videos, Your Honor, and make the ruling on the business plan in the 2020 coupon, still advertising.
The court grants it with regards to that and the request of counsel. The court's going to defer with regards to the 2 videos. And I had to reject your first OST, but we're going to figure out at the end of this day or tomorrow what we're going to
Judge,
do
I'm not
about
trying to quick pitch anybody, but that's why I thought it was the appropriate way to do it by filing a motion to file an addendum.
I'm hearing what you're saying, but you can also appreciate, in fairness, when we already had things specifically teed up for today to try and say that UDCR does A, allow me less than 24 hours, B, in fairness to all parties, yeah.
I thought the deposition Monday would be good, but I had no idea he would testify that he met with Mr. Walters 15 times when Mr. Walters said he'd never met with him. I had no idea that would happen.
So the court's granting in part with regards to the 2020 still, which is set forth in the pleading, as well as the business plan in a redacted form. If there's a dispute as to what should and should not be redacted, then the parties will need to bring that to the attention of the court. And we're going to need to find a date at no later than by which you need to bring it to the attention of the court. So that everyone, it's going to basically going to need to be before your 2.67, right? But we're going to need to find a date and how we're going to address that. So please put that on your to-do list to remind the court while we move forward with a couple more of these with regards to the portion of the 2 videos that are referenced that were done between 2010 and 2019. The court's deferring it. Counsel's request, and we're going to need to find some time for that. Okay? It is so ordered.
Thank you.
Thank you so much. So moving forward to Document 663, plaintiff's motion eliminating number 11 to pre-instruct the jury on standard product liability instructions. Let's hear some oral arguments on that in light of the stipulation that I still have not seen.
Can we print now, Your Honor?
If you want to pause for a second and print, I mean,
We have one
has
copy.
ETT had an opportunity to even see it?
That's what we're gonna print, enough copies so everybody can see it.
Just one.
One we pass. one
I can't
stop
see it
with
until
ETT.
they've had a chance to fully address it, and realistically, in the middle of a hearing, to ask them to address it and approve it if they want to, that's fine, but if they tell me that they need to actually look at it, as you know, under the rules, right, you're supposed to give sufficient time for anyone to review something before it gets submitted to the court, so the reason why I'm just going there is your pre-instructions, I need, once again, so ETT, what do you want to do? Because I need to figure out, moving on to this next motion, or if I have to move on to a different one and circle back to that one.
Your Honor, I just was handed this. We would like an opportunity to review and respond.
Okay. So we're putting document 663, we're not going to address that today, so I need to give counsel for ETT an opportunity to see if that impacts the discussion with regards to that. The court finds no prejudice to anybody because you all could have submitted this proposed stipulation earlier. Okay, so we're moving instead to document 664. So that is ETT. Document 664, plaintiff's motion eliminating number 12 to designate Blaine Jones as a managing speaking agent of Real Water with an opposition of Real Water, document 814, plaintiff's reply 933. Counsel for plaintiff, go ahead, please.
Judge, if I may, can we take a quick bathroom break before the end of the day, or?
Yeah, do you need it now? We'll take another one now. Sure, come back in 10 minutes. Okay, thank you. Here, okay.
Thank you, Judge.
Go back on the record, no worries. We're back on the record. Same case, same parties. We're about to start document 663. Plaintiff's motion, document 664. Plaintiff's motion eliminating number 12 to designate Blaine Jones as a managing speaking agent of Real Water. Did you put it back on so they're no longer on mute? Remote people? Okay, no worries. I can't tell because the screen's blank. No worries. I just want to make sure. Okay, as a managing speaking agent and opposition of Real Water, document 814, reply, document 933. Counsel, go ahead, please.
Your Honor, you got any leanings one way or the other on this one?
I need to
Or
hear the
any
difference between
questions?
Blaine, no, I don't.
Okay.
I know the difference between Brent Jones, Blaine Jones, who was 30B6 on a couple of topics, but I need to kind of walk through how each party's viewpoints, but thank you.
So Blaine Jones is the son of Brent Jones. Blaine was the executive vice president for, I think, 16 years at Real Water. He was the secretary and treasurer as well. He was designated as an officer. In fact, during the trial in Gallagher just a couple of months ago, he was still identified as an officer. And for purposes of this motion, which is important to the court, he held those positions when his deposition was taken. He was designated by Real Water as a 30B6 witness on behalf of certain topics, Your Honor. So under Rule 32, we believe we should be able to use his deposition for any purpose as he is tantamount to a party, Your Honor. And so we also cited, in addition to NRCP 32, subparagraph 3, NRCP 30B6, and Wright and Miller 8A Fed Practice and Civil Pro 2145, Your Honor. In terms of the statute, we cited NRS 50.115, subparagraph 4, allowing plaintiff to cause an adverse witness, a party from Real Water. Your Honor, Real Water's opposition seems to suggest because Blaine Jones is no longer an officer. That's not a very persuasive point, Your Honor, because he was an officer when he was designated. And all of the conduct that we're speaking of took place when he was an officer, and not just an officer, the executive vice president, Your Honor. He didn't Real Water's opposition indicates that he stepped down in 2020 from management, but it's weird. His stepping down really involved him taking over the relocation of the operations from Desert Inn to the Henderson location and to Mesa, Arizona, Your Honor. And that the topics that he was designated to discuss during his 30B6 testimony was manufacturing of the concentrate, Your Honor, which is, the heart of this case. So, Your Honor, I don't believe that there's any way this witness can not be seen as a managing speaking agent for purposes of Rule 32. And I don't believe that the comments are in the opposition are well taken, given the part he's played in the FDA Southern Nevada Health District and CDC investigation. In fact, in our reply brief, we talk about how the CDC and the Southern Nevada Health District referred to him, met with him. He took part in the establishment inspection. He's listed, in the EIR report of March 16, 2021. He was the face of Real Water throughout the investigation, Your Honor.
What does the court do about the fact that he was only designated for, I believe it was 2 of the categories, right, for 30B6? And part of his deposition testimony that's quoted in the opposition says that he specifically stated he did not address certain areas. I guess it was customer complaint, sales, and something else, but it was at least those 2.
Your Honor, I think that's a half argument on their part, because they're saying because he was not a 30B6 as to all topics, he shouldn't be allowed to be a managing speaking agent on those non-topics, except that he still satisfies the requirement of being the executive vice president under the Palmer case. And so he still comes in as a managing speaking agent, Your Honor.
Okay, appreciate it. Thanks very much.
Thank you.
Real Water, you have an opposition. Would you like to be heard?
Yes, thank you.
Okay.
Good afternoon, Eric Freeman on behalf of Real Water. There was no legal basis for plaintiff to designate Blaine Jones as a speaking agent. In fact, Blaine Jones is a plaintiff in another Real Water case. He has an attorney-client privilege with plaintiffs, but they want to make him the speaking agent because he was a former officer of Real Water. He was the vice president, but he resigned in April of 2020. And then soon after, Real Water went into bankruptcy. So just because Secretary of State website happens to still show officers of Real Water, well, once he resigned, Blaine Jones wouldn't go and remove himself as an officer on a website. Real Water was in bankruptcy, and so any of their activities were only focused on bankruptcy-related activities. They weren't doing anything with the Secretary of State. They weren't doing any type of corporate acts. They were bankrupt. And you mentioned the fact that they want to designate him as the speaking agent for any and all topics. In depositions, he routinely said, I don't know about that. I wasn't involved in that. You need to talk to Brent Jones about that. You need to talk to Amy Jones about that. I don't know about that. That's why he was designated solely for 2 issues, very limited issues. And it was the manufacturing of the Real Water and the manufacturing of the Real Water concentrate. And so he is not in a position to be a speaking agent for Real Water for all issues, especially because of the fact that he's now a plaintiff. And he was not an officer at the time he was deposed. He had resigned years prior. So he does not fit the criteria to be a speaking agent. He was only designated for a limited issues, and he clearly said that he didn't know about certain issues. Or he would say, you need to talk to another person about that, not me. And so it's just inappropriate that plaintiffs would try to designate him as a speaking agent.
How are you suggesting that the court determine whether or not he falls within the per se language of 32 at the time he was deposed, right? They've put certain information on what Wyoming's Secretary of State website and some other documentation, and you say he stepped down in 2020. So how is this court supposed to resolve that discrepancy to find out if he falls within the per se language, right? It was 32.
Well, I think not only is the fact that he actually resigned, and so therefore he is not the officer just because the website says so, but also.
What do we have that he resigned? Is what the court's trying to look at is what actually is the evidence before this court that supports your statement that he does not fall within the parameters of NRCP 32 at the time he was deposed. I heard argument that he resigned, right?
Correct.
Argument that there's a bankruptcy, so I guess de facto he resigns or doesn't have the authority. But then there's other evidence. That's why the court was asking the question is, how does the court resolve whether he falls within 32? How do we know he resigned? What's the independent evidence? Is there a declaration? Is there anything that says he was no longer an officer?
I believe there's testimony to that effect. And regardless, we know that the company's bankrupt. There are no more officers or directors, or the company is essentially dead.
But I don't think you're contending that if a company goes into bankruptcy means that you no longer can have any managing speaking agents, are you?
Well, I mean, you can, but it's also, if he was going to be a speaking agent, it would be on those limited topics that he was designated for. You can't make someone who doesn't know things about a company and say, well, we want to make you the designated agent just because you were once an officer. Even though now that at the time of deposition you're not, you were once an officer, and so we want to make you the designated agent for everything. When Real Water went and said, okay, here are the two limited topics that he is designated for.
I appreciate it. Thanks very much.
Thank you.
Counsel for Plaintiff, you get last word.
I
I'm
appreciate
going to
it,
ask you the same question on the,
Yeah,
how do we
I'd be
know
more than happy to
what
answer
he
it.
was at the time he was deposed? What has this court been presented that shows clearly one way or another, or maybe it's up in the air? Go ahead, please.
Your Honor, there's no dispute that he was still an officer with the Secretary of State in Wyoming as of 2 months ago, certainly while he was deposed. And there's no opposition to that. You didn't hear any opposition. In fact, you heard in a way of trying to conflate or circumvent the question, well, Your Honor, they're in bankruptcy, so really the company's dead and there's no officers. Well, that's not true. The company still has officers throughout a bankruptcy proceeding. So there is no evidence showing that he resigned, he was removed, he's no longer an officer. There's no evidence of that put before this court. The other thing, Your Honor, and you started out asking Rewarders Counsel this. Looking at NRCP 32, it's an or. It's not a requirement that's and or and. It says an adverse party may use for any purpose the deposition of a party or anyone who, when deposed, director, managing agent, or designee under Rule 30b-6. They don't have to be all of those things, just any one of those things, Your Honor. And so, based upon our motion, your questions to Real Waters Counsel, their inability to show you any evidence to the contrary, we ask that the motion be granted.
Okay. And the court is going to grant the document 664 plaintiff's motion eliminating number 12 to designate Blaine Judd as managing speaking agent of Real Water. In so doing, the court's not precluding anyone from Real Water to say that, other topics other people may be knowledgeable on, but realistically, based on what has been presented to this court, and the only evidence it has as to Mr. Jones's specific status at the time he was deposed is realistically the footnote that addresses the Wyoming Secretary of State. I don't have anything that says he was not, and if you look at the language as quoted, both sides quoted it, but also on page 3 of the motion, any purpose of NRCP 32A3 provides that an adverse party may be used for any purpose. The deposition of a party or anyone who, when deposed, was the party's officer, director, managing agent, or designee under Rule 30b-6 or 31a-4. What it does not say is that if you carve out them for only certain parts of 30b-6, that somehow says that they could only be a managing speaking agent for those specific topics. No one's presented any evidence that would have a narrowing that is argued, so the court needs to grant the motion for motion eliminating number 12. Moving on, motion eliminate number 18, which is document 652 with an opposition, document 835 by ETT, a reply, document 928, And that's motion eliminating number 18 to preclude reference to the fact that Brian Jones is now a plaintiff. With Real Waters joinder to plaintiff's motion in limine.
Yeah, Judge, this is kind of a bad law school exam, okay? We have a situation where the person who made the water, or made the concentrate rather, Blaine Jones, drank real water, went on some trip up in Utah, got real sick, was diagnosed with acute liver failure, was counseled about transplant options, came this close to being flown to a transplant center, was investigated by the Southern Nevada Health District, is one of the 25 probable cases. He's one of the cases, Mr. Blaine Jones. And in his deposition, he said he thinks it was caused by the real water. So we have a company officer, and the one that was most intricately involved in the operations, because Brent Jones wasn't really around on a day-to-day basis. And when we took his deposition, I asked him, well, are you going to sue? You know, are you going to file a suit? And he said, no. I've consulted with an attorney, and I've decided not to file a suit. That's what he said when we took his deposition. After that, he retained Mr. Christiansen, and he has filed a lawsuit. So he is technically on record here in Clark County as filing a suit. There's a little issue whether the bankruptcy trustee has released his ability to file suit. I don't want to get into that. I'm just going to assume he's filed suit. So in our motion, we brought out how this potentially cuts both ways. Because me, as the plaintiff's attorney, I can get up now and say, aha, the officer of the country that made this stuff thinks that real water caused his acute liver failure, so it must cause everyone else's. So that cuts my way. Okay. They are saying that it cuts their way, and we point this out in our motion. I thought we were real honest and forthcoming about this. And we said, well, yeah, there's financial bias argument here too, right? Even though at the time of the deposition he did deny that he was going to file suit. So I said in the reply, look, it goes both ways. You know, I just want a clear, bright line rule. Because if you let in evidence that he's the plaintiff, I'm going to take full and complete advantage of it, starting with the opening through the whole trial. If you keep it out, I'll honor that too. So whatever the defendants want to do, Your Honor, that's what we've said we'll live with. But we just want to make that real clear for the record that we are not taking a position one way or the other, because I don't want to get up on appeal and have some Supreme Court justice say, well, Mr. Kemp, you kept saying he was a plaintiff and you were just trying to enhance your blah, blah, blah. And I want to be able to say, Judge, I didn't take a position on this. The defendants decided that would come in. So whatever they want to do, Your Honor, I'm fine with. Either we can call him a plaintiff, we can keep it out. Either way.
Which is, so it's a modification of your actual motion, correct?
Well, actually, I kind of say this I say this a little bit, I kind of throw it open in the motion, but in the reply, I specifically say this, Your Honor. So I don't think it's a modification. I think they've known my position. And this was the same position we opted for in Gallagher, or that we offered in Gallagher. So whatever they want to do.
I'm sorry, you said.
So in Gallagher, we took the same position. Whatever the defendants want to do, we'll do. So we had a little complicating factor there. We had 4 defendants, so it was hard to get them on the same page sometimes. This case, we have 2. So whatever they want to do, I will live with.
Okay, well, I have 2 different positions. So Real Water, I'm going to you first because you did a joinder to the motion.
We don't have anything further to add.
Oh, I see Mr. Odou standing up. I guess you do? Okay.
I'm sorry.
Okay.
Nothing important to add.
Okay.
Glad we're all on the same page.
Who's the managing speaking agent on behalf of Real Water to decide whether or not you want to say something?
Hopefully not the 30B6. Joul Odou on behalf of Real Water. Actually, I'll be very brief, Your Honor.
Okay.
This really is no different than some of the other motions eliminated the court has heard and will hear in terms of other lawsuits don't belong in this case. And that's just the fact. It just introduces too many potential pitfalls for a mistrial. We have Mr. Blaine Jones, the son of the owner, has his own case, his own lawsuit. We don't know by the time this case goes to trial where that lawsuit will be. We run the risk of if that lawsuit is settled, if that then we can't ask him. I mean, there's just so many different ways that this could go wrong. So in the other case, we argued this, we're arguing it in this case. We think the danger of prejudice or the danger of some inadvertent statement such as, the company's no longer in business, I sued them. There's so many different ways which would violate several Nevada cases. There's so many different ways this could go wrong. We were ultra careful and will be ultra careful in this case in instructing all of our witnesses, and I'm sure the plaintiffs and the other defendant will do the same thing, as to the rules and regulations of this court and what testimony is out of bounds. If the court rules that this testimony is not out of bounds and that he can be asked about his lawsuit, we open up way too many cans of worms. And so that's why we think his other lawsuit should not come into evidence in this case. It's just too problematic. It's too prejudicial. There's certainly a ability of Blaine Jones to separate the two out. He testified in the other case under cross. Actually, they played a video. Did you get sick from drinking real water? That's not even at issue. We're not contesting he didn't get sick. That was his lay testimony.
Okay, so this is where the court needs a point of clarification, right? Because until you said playing the video getting sick, it seemed like all three of you all were on the same page, because specifically in ET&T's opposition, accordingly, Terrible Herbst believes that testimony regarding Jones's injuries should be precluded altogether. But if the court allows such testimony before the jury, then consistent with Nevada case law on this issue, the jury must also hear that Jones is a plaintiff. So realistically, when I read everyone's pleadings, particularly when focusing on the reply, it seemed to me everyone was in agreement that Mr. Jones does not discuss his injury and Mr. Jones does not discuss his plaintiff status. And the only thing Mr. Jones discussed is what the court just ruled in the last motion, which has limited aspect with regards to employment/office or so related aspects. So I need to find out if you all are on the same page. Are you on that page, or are you saying that?
So we agree. We would love it if the court rules that he can't talk about getting sick. That would be fine with us. We have no objection to that. A different judge, a different case, said the line was in a different place. So really what we're asking the court to do is draw a line as to what's in bounds, what's out of bounds. In the Real Water's view, his illness, his agreeing with the plaintiff's counsel that you couldn't pay him $10 million to go through liver failure again, we believe that's out of bounds and that should be excluded. I'm sure the plaintiffs would love to tell that to the jury. They told that to the other jury. And so that's why we believe that's another piece of this testimony we think should be excluded. It's just too prejudicial. It opens up all of these cans of worms. It's a slippery slope. We understand the court's got to draw a line somewhere, or not draw a line, but we think the court should draw the line that he does not testify about his own illness or his own claim.
Okay, let me go to ET&T. You get last word, counsel for plaintiffs, so let me hear ET&T's position first. Okay, counsel ET&T, whoever's taking that on, please.
Tomasik for Terrible Herbst. Judge, we join in the concerns of Real Water as laid out by Mr. Odou. This motion was laser focused. It was to preclude reference that Blaine Jones is a plaintiff. We think that if his alleged injuries do come in, we need to tell the jury that he's a plaintiff. It goes to financial incentive, bias, and motive. And with that, I'll submit.
Okay, thank you. Counsel, you get last word.
And I will just say...
Sorry, you're not submitting. Go ahead, please.
I apologize. I will just say we filed a motion to exclude reference and such testimony by Blaine Jones, but it's coming after in sequence.
Okay.
Mr. Odou brought up two concepts that weren't addressed by the motion, which is whether or not the injury should be precluded, which that is addressed by other motions. That's not addressed by this motion. Our position on that would be he's one of the 25 probable cases. Of course his injury comes in to prove causation, especially when they're disputing causation. Real Water is in the Brody case, and Terrible Herbst is disputing causation on the other case. So under the the case law, and Mr. Pepperman alluded to it. I didn't want to get into this in detail because this is the subject of another motion, probably 2 or 3. But we're entitled to prove other cases with similar exposures, not just for notice, but to prove causation. And that is, there's at least 4 different Nevada Supreme Court cases dealing with strict liability that say exactly that, causation. So he's one of the 25 probable cases that have been determined by the Southern Nevada Health District. His case...
Do you need to use his name, though? And therein lies where the court's going, realistically, right? If your concept is notice, right?
Mm-hmm.
Do you need his name?
Well, then how are we going to establish where he got the water? I mean, I think they're going to want...
My hypothetical is going to get you all a stipulation, right? Because to eliminate some issues here, because the issue of bias raises a very interesting issue this court has to evaluate because...
If they want to say he's plaintiff, I'm fine with that, Your Honor. I've already said that. But to try to sweep out the other factors, the first one is the causation evidence. And then the second one is when we took his deposition, and again, this person is he was the executive vice president. He made the concentrate. He's probably the person most involved in the process of anyone. And he went through the exact same injury, the exact same thing that everybody else did. And so during his deposition, we asked him to evaluate that, and he said it was worth more than $10 million. That's what he said. And there's been no motion to exclude that. You know, so for Mr. Odou just to stand up and say, well, let's throw that in here. There's no motion filed to exclude his evaluation of his individual case, Your Honor. So that is testimony that we played in the Gallagher case. To be honest, it didn't get us very far because the jury just gave everybody $2 million. So they didn't buy his evaluation. But it is admissible evidence. It's by at the time he gave it, that was his deposition. He was a corporate officer, so we can use that anytime we want. But that shouldn't be swept in the rug here, okay? It shouldn't be, well, we're going to call him a plaintiff unless you exclude his case. You know, his case has got to come in, and I just don't see how they're going to present his case without saying his name, because his story is that he was working on setting up the Henderson plant, that he became somewhat fatigued when he was up in Utah, and he was overworked, and so he got 5 gallons from real water, went up to, I don't know how you tell the story where he got the product, and it tied into Henderson, because he actually got it before the Henderson product was distributed. So how are we going to I just don't see how to sanitize it. If they don't want to talk about him being a plaintiff, I'm fine with that. It sounds like Terribles and Real Water have a dispute on that point. Like I said, I'm not taking a position on that. So I don't want to be hung up on appeal on it. But if they're allowed to call him a plaintiff, and I'm fine with that. You know, I've already said I'm fine with that. I'm going to take full and fair, full and complete advantage of it.
Okay, here lies the challenge. Yes, you all put as number 40 on your list, right? Was document 671 ET&T's motion to exclude the evidence, reference, and testimony related to alleged injuries sustained by Blaine Jones. You also have another one with regards to other document 617, Real Water's motion limiting number 9 to prove customer complaints and evidence predating the complaint. And then another one with regards to customer complaints is hearsay. So there's a plethora of various motions that tie into this concept. So here's what this
we
court...
grabbed the bull by the horns because we filed a motion to pre-admit all these customer complaints.
Yeah, I'm getting there. I'm just saying, I got them on each side. So here's what I'm going to tell you the inclination is. The inclination for and I'll give you each a moment to see if maybe you want to work out some kind of agreement. My inclination is to, in the revised version of where plaintiff doesn't really take a position, I'm really focusing on the non-substantive joinder, which technically under the EDCR doesn't stand alone, but since there was a change, I'm treating as if it does stand alone. Okay? My inclination is to allow just the reference that Blaine Jones is a plaintiff for bias purposes. because I think the jury will need to hear, and in order to evaluate his testimony and whatever he says, that you have to let that in for that limited purpose for bias in a very limited sense, okay? So that technically would mean I'd be granting it in part, right, to say just that he is a plaintiff as a factual statement, so it allows the jury, consistent with potential jury instructions, consistent with the whole introduction, that you have to evaluate each witness and their bias, right? And otherwise, I think you have an incomplete story that is not specifically referencing the upcoming motions. However, since I give inclinations, I'll say inclinations is consistent therewith. If you're having a bias concept with regards to saying that he is a plaintiff, is to allow very limited how he falls within that plaintiff if it goes to the strict liability notice component that is going to need to be dealt with in a few moments. How far you go into that and how much you get into that, I'm going to need to reserve till those motions come directly before me, okay? So, does anyone wish to be further heard on where I'm treating that right now as an inclination? So, counsel for plaintiff, do you want to go last or first?
I just wanted to point out, we think it's relevant as to causation, not so much notice that his injuries.
Excuse me, causation.
Right,
Well,
right. I think that's what
but you
meant.
have your notice component with the strict
Right.
liability, once again, depending on whatever this, right? If I were to look at the best guidance I so far have of some proposed stipulations that I don't yet see, right? But you all have asked me to continue to rule because based on the oral representations and what the content and the scope of the stipulation is, then I have to look at it for two prongs in light of the carve-outs, etc. You got the causation carve-out, but you also have the potential prior notice carve-out, plus you have the Southern Nevada Health District consistent with the court's prior ruling and how that's going to be tied into some of these cases, right? So that's why the court's inclination is as it is. Counsel, I'm going to give if anybody wants 2 or 3 minutes, I'm treating right now as an inclination. And go ahead, counsel for Real Water.
Thank you, Joul Odou on behalf of Real Water. It won't even take that long. Your Honor, I think that the issue is one that the court constantly confronts in these cases. It's a balancing act between where do we draw the line. And I think in this case, it's important to draw the line brightly so that the witness doesn't screw it up. And so certainly if somebody calls Blaine Jones, we will counsel him as to what he can and cannot say pursuant to emotional limit. But to go to the issue of notice for a minute, because I think that's really interesting, and I think the court has commented upon that several times today, but I don't think anybody's addressed it. The notice isn't, Real Water has not disputed that hydrazine was found in the bottles of water or that hydrazine caused some of these plaintiffs' injuries. So there is no notice component that the plaintiffs need to prove. The plaintiffs are saying, oh, well, we're going to call Blaine Jones to prove Real Water could make you sick. That is not a disputed fact in this case. And that's why this doesn't go to notice.
I'm hearing what you're saying, but I will tell you, after already spending most of the lovely day with you all, right, since 9 a.m. this morning, I'm hearing different perspectives from different defendant parties. And I have different pleadings. So while I'm hearing Real Water's position, this court's being careful to really say, right, it is an issue in the case. I'm not saying whose issue it is. It is being presented. It is still an issue. It is briefed multiple times by a variety of different parties in different contexts in different matters before this court. So until somebody tells this court that it's no longer an issue from all parties, I have to treat it as a current issue, or until I make a ruling that somehow would eliminate it as a, quote, current issue. As of this stage, there's not been either, so I have to treat it as an issue. I'm hearing what you're saying from a Real Water perspective, but remember, that's as of the oral statements in court, right, this morning, which I've been told I'm going to have objections from ETT, right, and that they haven't even had a chance to review. So I have to take the current landscape, not what somebody thinks the picture might look like on the first day of trial, right?
That's right, Your Honor, and we appreciate that. And the court has only had the benefit of a couple of hours of argument here.
Well, yeah.
Whereas, these parties have been through one trial and litigated. But so perhaps the court may want to defer ruling on this because this notice issue, I'm not talking about the stipulation, but this argument of notice goes across so many motions of limine, and there is no offer of proof that there's notice in dispute. We've concluded that. We've heard conclusions, oh, well, I can offer this evidence because notice is in dispute. No one has shown this court where real water is disputing notice, and that is the key issue. In other words, real water has never taken a position in this case that real water couldn't make these people sick. If real water took that
Excuse me,
position...
counsel, be very careful about that, because don't you recall a prior hearing where there might have been a different viewpoint between you as counsel and maybe a co-counsel as far as statements, as far as admissions of liability? Without going to the specific record of exactly what was said, why don't we just leave it as the...
Your Honor, I appreciate that, and I've heard my words quoted as what we argued in opening statement.
Oh, I'm not quoting you on anything. I'm just saying there's general difference of opinion between the two counsel, right?
Your Honor, I don't believe there is, because it's medical causation. That's the issue that is still in dispute as to Plaintiff Brody. Not did it cause her injuries? That's a very different issue.
I'm very cognizant of hours and hours of listening to hearings, being present at said hearings only in this case, without the benefit of what you all have argued in other cases. So this court focuses on what it is being presented in this case as it needs to for purposes of its rulings. So I'm hearing what you're saying, but remember the actual motion before the court that the court's ruling on is whether or not to, plaintiff's motion limine number 18, to preclude reference to the fact that Blaine Jones is now a plaintiff. That's the narrow ruling which the court is granting. There were 3 independent bases on which plaintiff presented on why, well, initially in their motion, then a non-position in the reply, a different position from real water, but then ET&T's position. So when I'm looking at 3 independent bases that would at least form independent bases on why should allow Blaine Jones, right? Right. That's what the court's saying. The court's not making an affirmative ruling on notice in it of itself, saying that that's presented as one of the bases that would allow the reference to the fact that Blaine Jones is a plaintiff, and it ties to also the bias issue. If Blaine Jones is going to be testifying, you need to know who Blaine Jones is. The court, in its inclination, because you all were referencing the fact that there's a lot of other motions that are not yet heard, remember what the court said initially. I'm not ruling any of those, I'm just kind of giving you an inclination, right, on how this ruling is, and I referenced the titles of some of the other motions. I said we'll address them when I get to them. So I'm not making any affirmative ruling on notice at this juncture, because that's stay tuned. And who knows what tomorrow's viewpoints might be, the various parties presented to me. It's an ever-changing.
It is, and it's a complex case. We appreciate the court's patience. Our position is it does not go to notice as to Blaine Jones because medical causation is in dispute, not notice of could this have happened.
Do you not think it goes to potential bias or having the jury have an ability to evaluate the credibility of a witness?
It does, but its prejudicial nature outweighs that bias because once the jury hears that he is a plaintiff, then we do not know what inferences the jury will draw from that. That is a stick of dynamite under this jury that could backfire on the plaintiffs, it could backfire on real water, it could backfire on Terribles.
But yet I have Terrible saying that they do want it in, and including the concept for bias.
And, you know, if they're going to light that stick of dynamite and see what happens, then, and the court's going to allow them to do that,
I don't view it as a stick of
them.
dynamite. What I have to view it as is a person's going to come in, that they have the opportunity. There's nothing that precludes the fact that he is a plaintiff, right? Because you have to get the full understanding of what in what roles he has when he is testifying, right? And it comes in all the time in, I'll take an example, and I'll give you a car accident case just as an easy example, right? If somebody's the sibling of a plaintiff in a car accident case, someone is the spouse, the partner, etc. It comes in all the time because of the viewpoint that you have to evaluate in what light that person is giving testimony. To give the testimony that they are a managing speaking agent of Real Water, that they held all these positions at Real Water, but yet have a state, how do you put that in context with a statement that does not say that there's other aspects of that particular individual? If you all stipulate you don't want it in, that's perfectly fine from this court. But at this juncture, this court, based on the case law, finds that I have to let it into the very narrow specific aspect is just a reference to the fact that Blaine Jones is now a plaintiff, which can be a very simple statement. Realistically, you all could put it in a statement that's just given to the jury at the time of jury instructions. You could do it in some other time. You could say that there's nothing else, you know. That is the clear only statement that's coming in at this juncture, right? Not everything broader. So,
just to conclude, on behalf of Real Water, we would certainly consider that. We would need to reflect on the different ways that a stipulation like that would play out. But we're open to the suggestion of discussing it with the defendant and with plaintiff and see if we can arrive at a solution.
I am fully appreciative that there's going to be some very challenging rulings that have multiple levels of it. I do not view this as a stick of dynamite. I do view it as consistent with applicable law so that you understand who each witness is. And since there is a broad history in ensuring that the jury right gets to evaluate the credibility of each witness, evaluate if there's any bias, etc. So, in that regard, now if you all want to do a different stipulation, this is an oral ruling from the bench, right? Division of Family Services, Rust versus Clark County, not yet memorialized in writing. Under EDCR 7.21, within the 14 days to the DC 31 inbox after said thing gets memorialized, right? Or possibly quicker so that you all have a trial coming up and your EDCR 2.67 obligations through 2.69. That being said, I
will yield the floor. I've heard what the court has said, and I'm pleased to talk to the other parties about a stipulation.
There's a lot of ways that you all can do what minimizes whatever parties wish to do, but
thank you.
As presented to this court, it does go to an aspect that I have to let that specific statement in. Okay, so let's move on to the next one. So I am phrasing this as granted with the limitation that is granted only to the specific fact that Blaine Jones is now a plaintiff. The court's not making any broader ruling with regards to Blaine Jones. I don't view anything broader with regards to Blaine Jones as before this court for this particular motion. Stay tuned, okay?
Yeah.
And that means I'm granting the joinder of Real Water with that very narrow, I'm denying the joinder, my apologies. I'm denying the joinder of Real Water with regards to that ruling. And I inadvertently said I granted precluding reference. What I meant to say is I meant to say I deny. So let me go back and clean that up for a moment. Thank you so much. It is late in the day. Okay, document 652. Plaintiff's motion eliminating number 18 to preclude reference to the fact that Blaine Jones is now a plaintiff. That is denied without prejudice with a very narrow, and the joinder there too is also denied without prejudice with the very narrow statement that the only thing that can be referenced is the fact that Blaine Jones is now a plaintiff. The court's not doing anything broader with regards to the denial of said motion. The court's not doing anything affirmative with regards to anything else that can be said at this juncture. The court finds that the only thing before the court with this particular motion eliminate was that specific reference or that specific statement, and so the court's ruled narrowly based on what was presented to the court, and if the parties wish to modify it, I'd have to see a stipulation. Okay? That addresses that one. Anybody else need anything else on that one? Let's move to the next one. The next one is Plaintiff's motion, document 649, Plaintiff's motion eliminating number 15. Preclude defendants from arguing that they can delegate their obligations to government agencies or that prior permitting past inspections or compliance with other health and manufacturing regulations is a defense. The court's inclination therein is to grant in part and deny in part without prejudice. The court is inclined to grant it with regards to non-delegable duty. The court is inclined to deny it in part from to the extent it seeks to preclude a defense by either of the parties with regards to anything that is left with regards to, that's not subject to a stipulation. That would be an allowable defense to evidence presented by plaintiff. So granted, based on a delegable concept, but given the nature of some of those defenses, I think this is a little bit broad, so I have to deny in part to the extent it's unclear on some of the breadth of how broad you're going on that. Okay, Councilor Movement, go ahead, please.
Yes, Your Honor, I understand the court's concern with the breadth of the motion. It is a little bit difficult to understand the exact breadth we're looking for because we don't know all the arguments they can come up with under this umbrella. We did identify the prior permitting and past inspections as something separate from the delegation of duty issue. And I think, there wasn't really any direct response to that. The concern there is that the defendants were going to come in, primarily Real Water, was going to come in and say, oh, well, everything was fine because the Southern Nevada Health District, was there and granted us a permit. We submit that is a violation of NRS 41.133, which specifically provides that an inspection by a public agency does not warrant the absence of any hazards or other deficiencies. So to suggest otherwise not only violates Nevada statute, but also is just a confusing and unfairly prejudicial argument in light of the issues in this case. So we would ask that that be specifically added to preclude that type of argument based on prior permitting and inspections.
Including if it goes to the punitive damages stage, or is it only for the initial stage of the case?
Both, Your Honor. I don't think that the prior permitting is relevant to liability or compensatory liability or punitive liability, because the fact that the Southern Nevada Health District had granted them a permit is not relevant. They don't cogently argue how it's relevant. There's testimony that they received permits, but there was a lot of issues arising from these inspections, and we don't think any of them have anything to do with the claims for punitive damages in this case, which has to do with conscious disregard, ignoring issues, customer complaints, failing to investigate, receiving notice of similar incidents, complaints, and injuries, and not doing anything in response. The permitting aspect of this case is really not relevant to that, and I think that goes both ways. It just keeps irrelevant, confusing issues out of the case. And again, that wasn't really opposed in the motion. The other compliance with health and manufacturing guidelines, I do understand that is a broad umbrella, because I'm not sure what they plan to argue in the sense of compliance with those types of regulations as a defense. They, in their opposition, Terrible Herbst in its opposition, suggests that it plans to make some sort of argument in that regard, but it doesn't identify any specific regulations or laws that it supposedly complied with. There's no specifics offered in the opposition, just the broad assertions that they complied with unidentified laws and regulations and should be allowed to make those arguments as a defense.
Can I stop you for a quick second? Because here's what, remember, at least what you all told me last time, and I'm not sure in light of I had to use a different word other than landscape, in light of the changing parameters of this case. Is this case just products liability against Real Water with the certain agreements with Real Water and its negligence and strict products liability against Terrible Herbst, right? Because I have to look at that rubric with regards to this motion, right?
Yes, Your Honor. As of right now, those claims have not been waived or dismissed. As to Terrible Herbst, technically that's true.
Okay, so, right, duty breach, doesn't it go to breaches of certain duties, analyze, right, depending on how broadly this is read, doesn't it preclude them having a defense under breach? Feel free to consult.
We're ready to waive the negligence claims against.
You all need a brief, I mean,
No, Your Honor, I think Mr. Pepperman has it right.
okay. So-
Yes, we just plan to go forward on the strict liability claims against Terrible Herbst and Real Water, for which Real Water had the stipulation to admit liability and causation to the
Like
plaintiffs.
I said, an ever-changing landscape, folks. Okay, so now you're asking the court to analyze this just in one category versus both. Okay, keep going.
Yes, Your Honor. The motion, I think, was specific in its arguments that this type of defense is not relevant in a strict product liability claim. And so we asked just for the narrow ruling with that respect. And certainly if it's going to be denied in part without prejudice, I think it's fair to the court that Terrible Herbst identifies the specific laws or regulations that they plan to argue that they complied with, and how that was a defense, and I'd be happy to respond to those arguments.
Okay, let's just make sure, so is it plaintiffs, all plaintiffs' final position? Actually, it's only Hunwardsen, so it's only you all. I don't have to ask Mr. Parker on this one. So it's only Hunwardsen, right, with regards to Terrible Herbst? So I was just saying, I don't think I need to ask you,
That's
Mr.
correct.
Parker. I'm just asking, okay, I was about to use the plural plaintiffs, but it's really plaintiff because it's just Hunwardsen. So with respect to the Hunwardsen claims that is only a products liability claim and there's no longer a negligence claim, is that a proposed stipulation, or is that a withdrawal, or is I'm not hearing it correctly? I just need a clarification of what it is because I need to analyze this under the right.
Yes, Your Honor,
Claims.
Plaintiff Hunwardsen will withdraw his negligence claims against Terrible Herbst.
Okay.
And that's true with Real Water under the stipulation as well.
Okay, let me hear then from Terrible Herbst because they did the opposition, then Real Water did a non-substantive joinder. Go ahead, counsel for Terrible Herbst.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst.
You're happy, right? There's
I
only
am-
one claim less.
One claim, yes. So yes, I'm happy with that, Your Honor, but I still am faced with a punitive damage claim. And I think for that reason, the notice, there's probably three components, I would say. Real Water's compliance and with permitting. Real Water's lack of compliance with permitting at the Henderson plant. And then there's a third aspect, and that's Terrible Herbst and the fact that Terrible Herbst has not been found to have violated any statute, regulation that might be applicable. And I think that is relevant to punitive damages. In fact, in both the Robinson case and the Rader case, those cases are directly applicable and say that those types of facts would be relevant to punitive damages. Plaintiffs are going to come in and argue that we either knew, should have known, that we should have inspected, we should have run audits, and we're certainly entitled to refute that by showing that there's no requirement in any statute or regulation that we conduct those audits. There's also no requirement that we go inspect to make sure that the Real Water plant is properly permitted or hasn't been
Is a little bit different than how plaintiff phrased their motion. The way I was seeing plaintiff's motion was whether the duty is delegable or non-delegable because of government agencies, right? And then second, that a reliance on compliance doesn't eliminate the cause of action, which is now products liability only, with regards to each of the defendants. What I'm hearing you say is that you're saying that for punitive damages, you want to affirmatively argue compliance with something gets you out of punitive damages, or you're saying that it's plaintiff's burden to show that you didn't comply with something. If you wouldn't mind kind of clarifying.
I believe they're gonna come in and argue that we somehow didn't comply with some regulation and that we were required to go audit real water.
How on a products liability, counsels for plaintiff, are you going to do that on a products liability? Say that they were.
Your Honor, the punitive claim against Terrible Herbst is based on two prongs. One, they had a number of complaints. They didn't do any investigation. And as we pointed out in our motion in summary judgment number 2, I think it is. There's cases that say even if there's one product complaint, that's sufficient for conscious disregard. So that's the first prong. The second prong is that it was the industry standard to do third-party audits.
Okay.
Costco was doing third-party audits. Terrible Herbst didn't do any third-party audits, didn't require third-party audits. And as a subcomponent of that, we're saying if you're not going to require them to do third-party audits that they give you, at least ask for third-party audits done by other people.
But is that in your motion? Is that in this motion?
That's
because
not
if
this motion, that's in the opposition to the summary judgment where I think counsel's jumping to.
okay,
This is her motion for summary judgment number 2.
And Your Honor, I can comment too, that it is a little confusing because that's the next motion in limine 16, which touches on those types of issues.
But
there's a lot of overlap, but you are correct, Your Honor. This motion is limited to the delegation of duty and trying to argue, hey, we don't have responsibility for the product defect because of prior permitting or some compliance. It's limited to...
I saw this is historical and your other ones are prospective.
This is related to the strict liability claim, a defense to strict liability, only based on the Allison v. Merck case, precluding arguments regarding delegating duties. The next one is similar. I acknowledge the similarities and the confusion, but that I think is really what implicates the punitive damages and these arguments here.
In this motion, are you asking that defendants not be able to assert that they complied with applicable law, even though you all dispute what is industry standard, what may be applicable law? Are you asking that they are precluded from providing any defense to say that they did apply with applicable law in this motion? Is that the scope of this motion or not? Like I said, it's so broad, it's unclear. That's why I have to ask the question.
Yes, with respect to the prior permitting, health inspections, and things of that nature.
Oh, when you say things of that nature, right? Okay.
Health and manufacturing standards as required by the permitting and health department.
I think this is one reason this motion should be denied. I thought they were trying to preclude Terrible Herbst from arguing or offering evidence that Terrible Herbst did not violate any laws and that real water, at least as far as we knew, had passed inspections and was properly permitted. We weren't, purchasing water off somebody from a corner. This business was legitimate. And so we're entitled to raise those issues. If they're going to argue, as Mr. Kemp said, that we had a conscious disregard for industry audits or standards, then we should similarly be entitled to prove the opposite.
Okay.
Thank you.
Thank you so much. There's a non-substantive joined by real water. Do you wish to be heard?
Nothing to add, Your Honor.
Okay. Counsel, you get the final last word.
Yes, let me try to clear up the confusion here. So this one seeks to preclude the defendants from arguing that their compliance with the health and safety or health and manufacturing regulations, that requires the permitting, those types of things, the compliance with those are a defense to a strict product liability action. Even if they complied with every single requirement to get a permit or to make water or anything, that is not relevant to whether the product is defective or unreasonably dangerous. That type of argument that, oh, well, we complied with the permitting requirements, or we received a permit, or we were relying on the Southern Nevada Health District to point out problems, all that is irrelevant to their strict liability under plaintiff's product defect claims. So we seek to preclude those types of arguments in their entirety. 16
I'm
is,
not on 16,
I know, but it's a similar argument that I think
but we
implicates
can't
this.
go into because 16 is not on for today. In fairness, nobody else has been able to argue it.
I know, Your Honor, I'm not trying to go into it. I'm just saying the difference between the two. That's on this issue where she was arguing, well, we didn't violate any laws. That's that topic of 16. So again, narrow issue based on Allison v. Merck, which stands for the general proposition. The ultimate responsibility for ensuring the safety of the product is on the manufacturers and sellers who profit off making and selling the product. You can't point to the government agencies, the Southern Nevada Health District, and argue, well, we were relying on them to tell us if something was wrong, or they permitted us, they signed off on this. Those types of arguments, Your Honor.
Okay, here's the court's ruling. Court's ruling is as follows. Plaintiff's motion limiting number 15 to preclude defendants from arguing that they can delegate their obligations to government agencies or that prior permitting, past inspections, or compliance with other health or manufacturer regulations as defense is granted in part and denied in part. It is granted to the extent consistent with applicable Nevada law on products liability. It cannot be utilized as a defense for something being defective or unreasonably dangerous. It's denied in all other respects for two independent bases. It's too broad to really, and vague, to go to other aspects of punitive damages, etc. And so therefore, independently of that, it doesn't really articulate, not only is it too broad, but it can't preclude it as a defense for certain aspects which may go to punitive damages at this juncture where it's being presented, whether you view it as not being part of the motion or you view it as not consistent with applicable law. Either way, the rest would be denied without prejudice. It is so ordered. So we have gotten through all 17 that we had put on for today's motion calendar, with a caveat, of course, the caveat being that we need to revisit the first one, which was motion for summary judgment 533, and the other caveat that we deferred in part, document 663 in order to have a better understanding and opportunity for ETT to address the proposed stipulation, as well as we deferred in part document 685 with regards to the two videos in reference from the 2010 to 2019. The rest has been completed for today. So, folks, for tomorrow, what the court was inclined to do for tomorrow is the court was going to do, which you all was document 547, ETT's MSJ number 1, document 568, ETT's MPSJ number 2, document 543, Real Water's motion to amend, their answer. And realistically, if you're looking at the letter from December 1, you can probably figure it out. I'm doing those ones that I couldn't do for today because you all did not choose to give me courtesy copies that I could review everything. So we're going to put those tomorrow. So that means if you were to look at the December 1 letter, it's 3, 4, 5, 6, 7, 10, 12, 13, 14, and trying to get to 17 and 18 tomorrow, and possibly if we, and then revisit the summary, the couple ones from today, to revisit those, other than I'm not going to revisit the motion for summary judgment because I told you all you got supplemental briefing, right? So we're going to put that for next Tuesday. So we have the supplemental briefing being that one get taken care of, okay? So by Friday, that gets put to next Tuesday. And do you want me to go back to the pre-instruct tomorrow, or does ETT need more time than me putting that back on for tomorrow?
Yeah, Judge, I don't
Let me hear
think
from ETT first on the one that directs them.
Your Honor, if I could have some more time, I would certainly appreciate it. And if I may add to that, am I to, has the negligence claim been officially dismissed, or is the court asking for stipulation in writing on that?
but usually we just withdraw it on the record.
You can withdraw things on the record, EDCR 7.50, if there's a stipulation, it's whatever you all want to do. Counsels for plaintiffs, what would you like to do?
Stipulate to withdraw it on the record, Your Honor.
Okay, thank you, Your Honor.
Is that you agree to the stipulation?
I would agree with that,
Under
yes.
EDCR 7.50? Real Water, would you like to jump in on this one?
We have no position on this one.
Okay, then there it is. Okay, that took care of the second question. And so in light of the request by ETT with regards to the pre-instruction, I'm going to put that on for Friday rather than tomorrow. And then Mr. Parker, you had a question, so I was going to then address your questions. Go ahead, sir.
Your Honor, I apologize. I lost in the writing down of what's going to happen tomorrow. I got ET&T's MSJ 1 and 2.
Sure, no worries.
And then I
Okay.
got motion to
You have the
amend
letter from December 1, right? You all requested an order, which I couldn't do that order because people didn't provide me courtesy copies. Okay? So I could only do the ones that had the courtesy copies. So I was going to circle back because presumably you all still wanted that order to the best extent possible. And we're going to address the other issues tomorrow as well. And so that means if you looked at the letter of December 1, it would include what was number 3 through 7 on that letter, which is also on the December 12th letter. You all gave me a new letter on December 12th, so I was basing it off the first one, so.
Your Honor, I think there might be if there's a difference between the December 1st list and the December 12th list, it's just that one.
And no one redlined it or told me, and so you're not asking me to redo a whole order again, are you?
No, I'm just saying the December 1st list might have some motions on there that have been withdrawn pursuant to the stipulation in the settlement.
And so there's no red line or anything that would give this court an indication. Okay, counsels. So that means I prepared again for ones that I may not need to hear. So let's walk through those briefly because my wonderful team is now having to work overtime. Document 547, document 56, and I'm only doing the document of the motion. I'm not doing the document number of the opposition's replies and joinders, okay? Because A, that's the only thing that's on the December 1st letter, so I can't do it, but B, just be quicker. So document 547, document 568, document 543, document 595, document 592, document 676, document 610, document 673, document 623, document 677, document 674. And
Your Honor, I'm sorry to interrupt, but I think there was one on there so far. I believe you said it was 592, might have been number 7.
592 was the UNFW motion for separate trial under 42B. I appreciate that they were resolved, but they were resolved before December 1, and I still saw it on the December 1 letter, so I prepped for it. Are you telling me I didn't need to prep for it, counsels?
Unfortunately, I am, Your Honor. I apologize.
Because we asked this in open. So, I guess I'm not hearing 592. You understand what you're doing to my poor clerk, right? Okay. So then that means also 625. So what that should do, is there any other ones that have been withdrawn that I don't yet know about?
625 I have is ETT Mills 2 to preclude plaintiff's expert, William Hudson.
Yes.
That hasn't been withdrawn.
I'm asking the totality of all the numbers I just said. Is there any other ones that have been withdrawn that nobody told the court about?
Oh, no, that was the only one.
Is that correct from Real Water and ETT?
I am double checking.
We haven't
Four to
withdrawn
go.
any, so.
So far, I've not found any that are moot. Two more to go.
It should be all the Friday ones. Yeah, thank you. And I added one more 6:25 just because, okay. So what that means is remember what we're doing for purposes of placeholding, because my wonderful clerk, because you all have presented many challenges with regards to your ever-changing motions. Instead of asking her to keep resetting these on each and every day over and over and over again, you'll see tomorrow has 71 of them, but I've specifically told you which ones we're intending to do. If we get a little bit farther, we get a little bit further, but realistically, if we get those all taken care of, remember, we still have to make sure you all have, hopefully by this juncture, have already gotten all your exhibits, right, to the vault and got them checked and all virus checked. I'm sure you all have at least, right? I mean, in light of where your trial date is, it's 30 days out.
I believe the plan is to submit hard copy exhibits, not electronic.
That's not what you all told me previously. How are you how many exhibits do you have, counsels?
Don't have the exact number in front of me, Your Honor.
You understand, based on prior representations, right, that you all were using electronic exhibits like you did in Gallagher, right?
I don't recall.
You didn't use electronic exhibits in Gallagher?
We did.
Clerk with allocating her time, right? How is she going to get everything taken care of? Where are we going to have all of these?
I can assure
Counsel,
the court.
that presents, we'll discuss this tomorrow. I'm not having my team stay any later, okay?
Your Honor, I only have one other question, if you have.
Council's
a
5 o'clock. In fairness to
Oh,
my
okay,
team.
that's fine, we
Come
can
on,
take it up
it's-
tomorrow.
And
That's
remember, they
fine.
still have to download everything, and there's no way anyone's getting any discs from today. I'm not gonna ask them to stay even later, so you can appreciate, right?
Yeah, my question can wait, Your Honor, I appreciate it.
No worries, we'll deal with it. We're glad to deal with it tomorrow. And remember, tomorrow, you had no objections, and so our Nevada judges had asked that they could film from the jury box. So my understanding is they're planning on doing so tomorrow because nobody objected to do so, and the court was perfectly fine with it. Okay, so that's your friendly reminder there as well. Thank you so much, everyone. Have a wonderful evening.
Thank you, Your Honor.
Are we back?